Alright, welcome to today's video. The question today is, are releases from liability enforceable in Ohio? And like many legal issues, the answer is it depends. I'm going to use a recent case out of Ohio's 11th Appellate District to give you a little example. This is from Lake County, Ohio, and it's Beatrice Oliveri versus OsteoStrong. And Beatrice, she had arthritis and somehow got hooked up with this OsteoStrong and somehow received 2 free sessions with OsteoStrong. I'm guessing OsteoStrong is some sort of gym provided services for people with osteoporosis or other health issues. And so Beatrice goes to her first session and they do an assessment and they have her sign a release. And the important provisions of the release, I'm just going to read them here. First, I assume all responsibilities from my decision to engage in the OsteoStrong program. And second, I waive my right to pursue legal action against OsteoStrong, its owners, partners, and agents for any physical or mental anguish that I may incur as a result of my participating with the OsteoStrong system. So she signed that release at her first session, and then she did a quick session with one of the trainers there that first day. No issues, no pain, no injuries. Then she goes back for her second session. Different trainer this time. This trainer's working her harder, telling her to work harder, and she's trying to comply with the trainer. These trainers assured her that there was minimal risk of injury, and so she followed the trainer's instructions. Well, as she's trying harder, she hears and feels a pop in her back, and lo and behold, she sustained a compression fracture in her spine. She sues OsteoStrong, and OsteoStrong files a motion for summary judgment based on this waiver, saying she signed the waiver, they're not responsible. The trial court agreed with OsteoStrong, granted summary judgment, dismissed Beatrice's case, saying that the waiver was clear and unambiguous. So Beatrice's only option at this point is to file an appeal, which she did to the 11th District. And before I go into the holding from the Court of Appeals, let me go over some of the law. We're dealing with express assumption of risk here. That's basically contracting with another party to relieve them from liability because of their negligence. You're signing a contract agreeing not to sue if this other party is negligent. They're not very favored in law, so they're going to be strictly construed. And so there are really 2 things you need to look at for it to be enforceable. One, the person who's releasing the other party from liability needs to consciously know that they're doing this, consciously make that choice that they're going to relieve this party from liability. And 2, the terms of the release must be clear and unambiguous. Like I said, courts don't really like these. They're going to be strictly enforced, and ambiguity is really a term of art, and it exists when a provision at issue is susceptible to more than one reasonable interpretation. So the Court of Appeals looked at the 2 provisions I went over from the release. The first one, I assume all responsibilities from my decision to engage in the OsteoStrong program. The Court of Appeals said this provision is so broad that it has absolutely no meaning whatsoever, that it's pretty much a pointless provision. But then it went on to the other provision about waiving the right to pursue legal action for any physical or mental anguish. And the Court of Appeals really focused on that the anguish part of it, and in doing so just went to the Merriam-Webster website to get the definition of anguish, and that was found to be extreme pain, distress, or anxiety. Well, the Court of Appeals differentiated that from injury, which it again went to Merriam-Webster and found to be hurt, damage, or loss sustained. And it seems like the trial court, in granting Osteostrong's motion for summary judgment sort of used anguish and injury interchangeable. Well, in order to receive damages for negligence, the injuries don't have to rise to the level of anguish. They don't have to be that severe. You just need injury. You need some sort of hurt, some sort of damage. And so basically the Court of Appeals found that provision ambiguous, found that the release wasn't enforceable, and ruled in Beatrice's favor. So Court of Appeals reversed, sent it back to the trial court. So Beatrice is now going to get her chance to either go to trial or perhaps settle the case. So really, the point here is, releases from liability can be enforceable in Ohio, but even if one is signed, doesn't necessarily mean that it is enforceable. If you're presented with a release, you should probably consult with an attorney, get an opinion on whether it's enforceable or not. If you've already signed one and you've been injured, doesn't necessarily mean that you're out of luck. It may not be an enforceable release. So again, if you've already signed one and been hurt, probably want to consult with an attorney as well, because you may have some options.